this isn't so much of an issue anymore because the notion that there could exist a duty of care has gained so much traction, especially in the context of UK litigation. But I was just wondering whether it isn't still an issue in the sense that has just the possibility that there might be a duty of care has gained traction, but there hasn't been a case, where it actually has got to the merits, where the existence of the duty of care has been proven and hence could act as a precedent. So I'm not sure that we haven't really overcome that, and it is still, in my mind, a massive issue.
Thank you. Sandra?
Yeah, it was very interesting hearing what you said about the internal grievance mechanism from companies, but I wanted to hear a bit more, because what I heard from you is that it could jeopardize access to justice for victims, but you mentioned, I think, only the cost for companies, for law firm. But what would be your argument about the victim? Because some could say, they might earn more with this internal grievance mechanism. So I wanted to hear more about that.
Thank you. Carla?
My name's Carla Clark from Minority Rights Group International. Most of the cases that we're involved in are Indigenous people's property right cases, where personal injury issues are very small. So it relates to Robert's point about the language being used, that we're not using human rights language, and it relates to the way the cases are being brought here. And excuse my ignorance and also a long time since having studied tort, but are we looking primarily at personal injury cases? Or, are there opportunities for trying to bring essentially a property right case? Now, how do you put Indigenous people's property right cases into the framework that's being used?
Just really quickly, which is a little bit controversial about our proposal, is that it wouldn't be so much only linked to provided you can show a role by the parent. What we're suggesting is this idea that the parent owes a duty of care for human rights harm that arises as a result of actors within their operations. Controversial.
Thank you. The second question is about internal grievance mechanisms and access to justice, and are there instances in which a grievance mechanism could be of greater benefit to the victim than litigation? Do you want to start?
Yeah, well, clearly, if you think about settlement schemes that are often the end product of litigation, you could have a grievance mechanism which provided people with decent amounts of compensation and redress, and that would, to a large extent, obviate the need for civil action by victims, because generally what victims require is financial redress. It doesn't deal with the question of investigation and scrutiny of what has gone on or holding the wrongdoers to account. But what we're talking about in this case that I mentioned, the Tanzanian case, is a grievance mechanism that pays very small amounts of money, paltry sums of money. So it's in a completely different ballpark. And of course, they are operating in a place where the victims are vulnerable and are not in a position really to bargain directly with the company.
I think we should also think sometimes of the corporate position in this, that I would advocate that a corporation is much better very early on, as soon as they even begin doing a scoping exercise, begin consulting with the community groups, putting in place grievance mechanisms, so that, sadly enough for Richard, you never get to litigation. Because in the end, often that can resolve things very much more quickly than long-term litigation. But sometimes the corporates are just simply not interested in reaching that kind of resolution. But an early stage consultation, proper, fair and free consent can lead to a lot of resolution of matters, because it won't always be compensation in terms of financial terms. As I said, it could be moving an area away from a particularly important area for a indigenous group, or not causing problems to the water system. There are a range of activities that could happen very much earlier on than are often done.
Thank you. And lastly, opportunities for pursuing cases related to property rights.
guess that's me. The focus has largely been on tort law, negligence, but of course there have been a couple which deal with contract. I think one of the Thor cases had a contractual issue as part of it, employment contract, those kind of matters. And similarly, there could be matters which would arise out of a property right. You'd have to be able to put that as a private action for a property right. So it might well be a private action where there are land issues, obviously, which is often the case in minority rights areas, but put in terms where perhaps the issue could well have been the state's involvement rather than the direct corporate's involvement. So sometimes there could be a mixed claim which involving more than one entity, because you can't actually bring the case against the state in another court because you get issues of immunity that arise.
Thank you. We just have time for a couple more if anyone has anything. Yeah, we'll take all three. Yeah, here? Yeah.
Sorry, we have a microphone.
I've got a question regarding the whole attitude to remuneration being in money. I mean, if you're a victim of rape and bodily harm, shouldn't there be the possibility that people go to jail for this? I mean, getting a bit of money afterwards, which means nothing to the company, might not give the victim any sense of justice whatsoever. And if Siemens loses some managers into jail because of bribery, shouldn't we talk here about jail sentences and really significant jail sentences? Because I assume that companies then would actually wake up and do something about it. They might not care about the money, but if they lose their managers into prison, they will surely take human rights a bit more seriously than they do now.
Thank you. Yeah.
Hi, Sif Thorgerson from Business and Human Rights Resource Center. And actually, my question is directly related to what you were just saying. I was curious if the panelists could address whether you've examined any or governments would be interested at all in proposals which would effectively be like a death penalty for the corporation. In other words, your corporate charter would get revoked in event of certain grievous human rights abuses. And again, like the previous person just said, financial penalties, I think for many corporations, they can do a cost-benefit analysis and just say, yeah, okay, we'll just call it a day. But if your corporate charter will actually get revoked, again, that might be a little bit more of getting people's attention.
Thank you. And there was one more? Yeah.
Thank you, Sumida Narajan. You spoke about, Professor McCorkadale spoke about interpreting the harms more in human rights terms, and I wonder what opportunities there are under constitutional law, possibly not in the host states, but in home states. Thank you.
Thank you. So the first one was to do with forms of remedy and the need for individuals to be held personally liable and punished. Who wants to begin?
Looking at me. In fact, that's one of the reasons why I think we do need to consider the criminal law element. You're not going to have that possibility under civil law action, but a criminal law, which is certainly the route which has been favoured, if that's the right word, across the those with the civil law traditions in Europe, but it still hasn't gone very far. But certainly you're right, a corporation is much more likely to respond where there is that concern. Having said that, of course, the law has to enable there to be a tracing back to, let's say, the CEO, that actually they're the one who took that action, which is much, much harder to do. There are laws, of course, of corporate manslaughter now in place, but not necessarily for, as far as I know, corporate sexual assault. You could perhaps have arguments in terms of having in place kind of a institutional discrimination or institutional harassment. As far as I'm aware, there's not necessarily laws in place for the actual corporate responsibility for sexual assault. But we haven't really explored much here the possibilities in this country, for example, of criminal law as a means forward. But it certainly is a possibility which does lie.
I totally agree that criminal behaviour should be met with criminal sanctions. Having said that, I don't think you should underestimate the effect that civil action can have on a company. First of all, there's the cost. It can be very expensive, especially for certain companies. And the damage to reputation can also be significant. But most importantly, it's not correct to think that victims' main interest is not necessarily in money, because I can tell you that most of the victims that we have seen are impoverished and desperate for money. And money is more important than anything else. Not always. I mean, we have had cases where that isn't the primary objective, but it often is. And, you know, you have to follow the instructions and objectives of your clients. Also, sometimes criminal sanctions can be a complete damp squib. You know, in the Thor Chemicals case that I mentioned, where workers in South Africa were poisoned by mercury and 3 of them died, the company was prosecuted in the Pietermaritzburg Magistrates Court and fined the equivalent of £3,000. So there was a criminal sanction, but it had no deterrent effect at all. It was completely farcical. And the civil action, on the other hand, really was quite a salutary lesson for that company.
I mean, very quickly, I definitely agree that the right to remedy is not just a financial compensation angle. And in all of the cases that we addressed in the book, the cleanup, the environmental decontamination, and the implication on the right to health continues to be an outstanding issue. So I definitely agree, with that. The lens is much wider in terms of what is the appropriate reparation in a given situation and the different aspects that involves. But also to note, we have a project that looks at corporate crimes, and one of the examples or cases that was discussed in a meeting that we had actually was a South African case, and someone that was involved in the case actually said that as a result of the mining or the contamination in the mine, the director actually had to go to jail. And we were talking about how effective that was as actually a precedent in itself.
Thank you. Okay, the second one. Will governments be interested in the death penalty for a corporation? I think that the answer to that one's quite short. Things like the removal of license to operate, those kind of reforms.
I'll be brave enough by starting with, I'm sorry, I don't believe in the death penalty for anybody, let alone a corporate. The second reaction is there are ways forward on having the same effect. Stock exchange listing requirements is one, and it's certainly possible to have laws in place on that. I think we underestimate the possibility of corporate law. There's some corporate law, for example, in South Africa, which requires the directors to take into account the social impacts of their activities. I think that there are other kind of methods which might have the same restrictive effect, provided the corporation is going to be concerned about that. It may not always, of course, be in the location that you're bringing the claim, where the actual activity happens, of course. I'm going to embarrass you by thanking you, Sif, for all that you do in providing all this information to enable us to then comment on it.
I like the question. In terms of the response, the revoking a corporate charter is a little bit different from supporting the death penalty. It's a great idea and concept. One example that comes to my mind immediately is Union Carbide Corporation and their operations in India. And I can defer to one of my colleagues who could probably answer this more precisely than myself, but my memory is that they were then forbidden from doing direct business in India, Union Carbide Corporation, US-based Union Carbide Corporation. But then, as we know, they're now 100% owned by Dow Chemicals, and Dow has lots of corporate interests in India. So to me, it's this whole challenge of these different members of one corporate group. One element is shut down, but then the other elements are running. The ability to shut down, start up, move assets, challenging.
In the African Barrick Gold case that I mentioned, Tanzanian villagers who live in close proximity to the mine have gone on to the mine to gather bits of gold-bearing rock, and then, on occasions been confronted by the Tanzanian police, who were brought onto the mine by the company and shot, and in some instances killed. Now, there have been, I think, approximately 16 deaths of villagers on the mine, and a lot of people with very serious injuries. One of our clients is paraplegic. Now, if that company had been doing that, of course the company denies that it is responsible for what has happened, but if that had happened on a mine in Britain, that operation, regardless of whether the company was responsible or not, would have been given the death sentence. So why is it that Tanzanian villagers should be regarded as of less value than people here or in a developed country?
And lastly, human rights as a cause of action and opportunities under constitutional law. Robert.
Of course, as an academic, I'm trained to raise impossible points which are not necessarily able to be answered. The way I'd answer this is it depends on the constitution. There are clearly constitutional provisions in various constitutions, for example, the South African Constitution, which do allow human rights claim against a corporate. There's some very impressive claims that have been decided by the South African Constitutional Court on housing rights, on health rights, and those kind of matters. So if the national constitution allows for that kind of horizontal application of human rights, then it is possible. Unfortunately, that is fairly unusual across most of the constitutions around the world, but not impossible. Certainly in this country, the Human Rights Act is only applicable for public authorities, so it wouldn't be applicable here. But I think there are ways which one could be in time innovative. For example, looking at joint liability of the state and the corporate in, say, for example, pollution and things like that. So I think there are ways which are possible, but certainly would depend very much on the Constitution.
Thank you very much indeed. Please thank the panel.